Yeah, what was that?
Maybe so.
Oh my gosh. We're losing signal all around.
Is it up on the TV? And is it back on the TV now?
It's on now, but we have to launch the Zoom meeting, so.
And I got you Tuesday.
I guess we just had a brief.
People are still here. Just know I'm not qualified to fix the technology. So if I have a situation either. We got a good amount of people on here. I wonder if they can hear us. Oh, maybe it's that out.
I can hear you.
Yes, I can hear as well. Thank you.
Yes. You guys online, can you see the screen?
Yes.
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 I'll see if I can figure something out. I don't think so because we can't see them. Can you all see us or only the screen?
I
So
see
you-
both.
I can see both.
There you go. Cool, thanks, Nikki. You're welcome. I don't know what happened. Okay, cool. I'll close this. Good. There's the phone. There's the- We're gonna do galleries. And get started. Y'all know me, I'm Ashley with the Kelly Square right across the hall from y'all. As always, I put my cell phone on there in case you guys need me. Happy to answer questions over text, call me on the weekend, whatever help y'all need. Just know that I am here for you. And we're just gonna today recap all the changes that occurred in the mid-year updates for all of the GAR forms. Not a whole lot of earth-shattering changes, but we'll go over what they did change just so y'all can be informed.
Yeah, well.
Well, I'll just stand here, let me know if y'all can't hear me. So on the purchase and sale, there were a bunch of changes, again, nothing earth shattering and wild. But what they did change, this is really helpful for me, but what I want y'all to get out of this too is how to explain this to your clients and be able to advise them correctly. So y'all know in the title exam section of the purchase and sale, it basically says that the seller has to deliver good and marketable title. Is that the same thing as clear title or no?
Question.
The answer is no. There's almost never a truly clear title. So if that's the standard that we held sellers to, we would literally never get to do any closings. So good and marketable just means a title that a title insurance company licensed to do business in Georgia would insure without any sort of extra or additional exceptions to that title insurance policy. So for example, hey, how are you? Good. So, for example, if there's a really old security deed, an old mortgage on title, we can get the title insurance company to insure over it. It's not a clear title because that old mortgage shows up. It is good and marketable because the title insurance company has agreed to not list it as an exception on the title insurance policy. So that's the difference. As a reminder, this is not only for due diligence. This goes all the way up until and through closing. Okay, so if there's an issue on title, your buyer does not have to buy the property with that issue. They can tell the seller, okay, this is going to be an exception on the title insurance policy. I need you to get this corrected before I complete closing. None of that has changed. That's always been the case. What they did change was the very last part of that section on the title examination, part C. It's always said that the buyer directs any lender to quote the cost of title insurance, assuming they're going to get an enhanced title insurance policy. What they've added is that second part of the sentence, if such a policy can be issued on the property or for the buyer in this transaction. So what that is saying is, hey, you need to quote the enhanced policy, but only if your buyer is able to even get an enhanced policy. So not all properties qualify for the enhanced title insurance. So it's got to be a residential, it's got to be 1 to 4 family. So you can't like buy an entire condo building and get enhanced. Really, it's the idea is for a homeowner to have extra coverage. Anytime we're talking about some sort of owner that's probably not going to be their home or someone's home, then you're not going to be able to get that enhanced policy. If it's just a huge piece of land that's undeveloped, you're not going to be able to get the enhanced policy. And so this is helpful for us because people would say, hey, my contract says that everyone's supposed to quote enhanced, and you're not going to even offer me enhanced. We're not really making the call on whether we want to give enhanced or not.
Right.
We'd love to give everyone enhanced. The title insurance company only offers those policies in certain scenarios. 99% of y'all's closings are going to qualify for enhanced.
Right.
But this language is helpful for us. What I think is good to point out on this is there's a lot of lenders out there who don't know this paragraph exists and or ignore this paragraph. So I want y'all to be really careful about lenders who will say, hey, you should just waive title insurance, or hey, get a basic policy instead. And you say, well, why would a lender do that? The answer is that when they're trying to compete for the business, they might try to make their costs look lower than the next lender's cost. And so when they quote a lower title insurance amount, it makes their overall cost look better.
Especially out of state type.
Right, you're never gonna catch Shelter doing that, but there are lenders that will do that. And so it's really bad for your buyer. Really, the lender's not supposed to do it. Know that the lender is not a party to the contract, so they're not like contractually bound to do it, but they should respect the buyer's wishes. The buyer is their client too. And so if they have a document where the buyer has signed off saying, please quote me enhanced, they really should be quoting the enhanced policy. Just know that we can't change what those title insurance premiums are at all. So what I have, like if we're using, title insurance company, the title insurance company is different. So Alliance premium might be different than Fidelity premium. But whether you're for the same piece of property, the same sales price, if I'm issuing a policy with Fidelity, the cost is going to be the exact same as if another firm is issuing a Fidelity policy with the same property, same sales price. So we can't mess with that cost at all. So if someone says, hey, another law firm has it lower, probably what they've done is listed the basic policy if it's the same company. So just be aware that that occurs. Work with a lender who's going to really have your client's best interest at heart, not simply winning a deal no matter the cost.
That's only a couple $100 anyway, right? Between.
No, it's a little bit more than
Yeah.
that. Depending on the cost of the property, I would say like with average sales price, it might be $1,500. With the average sales price in this area, which sounds like a big cost for a buyer, but when you compare it to how much you would pay an attorney per hour to fix the issue, very cheap.
Right, if it's
Very
fine, you get it for it, yeah.
Yeah, so it's absolutely worth it, and just the peace of mind alone that it brings is more than worth it. You guys should always be encouraging your clients to get title insurance. There's not one single exception to that.
Right,
Even if mom owns the property and she just wants to sell it to her son should also get title insurance. We don't know what happened before mom owned it.
yeah,
A lot of people say, oh, it's new construction, I'm gonna be the first owner. No, you're not, the builder owned it.
for someone in the house, another land.
Exactly. So always encourage your clients to get this. I would always have a conversation, if I was you guys, I would have a conversation with them and then send an email, hey, I just wanted to recap what we talked about. You know, confirm that this is what you remember, however you wanna word it. Then you have an email that you can keep in your file that shows you told them to get title insurance and that they confirmed that they heard you say that. That way, if they waive it at closing, it's not your problem, because when they call you back in 5 years yelling at you that you didn't tell them to get it, you can say, oh, but I did. Here you go. And we have them sign a waiver if they're not getting it, so happy to share that.
I think once you give people options about something they don't really understand, they tend to make the wrong choice, like it's almost mandatory to get the parents. You gotta get this. You should
Yeah,
never know.
so we are not in the habit of saying,
I know.
here's all of your options, what do you want? We default to the enhanced policy
Right,
unless someone asks us to do something else.
right,
Mainly because they've asked the lender to quote it and we represent the lender, so we should also not take advantage, but we should also follow that direction and set it up to be the enhanced policy. Owner's title insurance is optional. Again, I don't really present that, make a big deal, because to your point, if we say it's optional, they see the cost of it, they just think, ooh, I'm just gonna skip it.
right.
But that's not really a wise thing to do. So closing costs, they did make a slight change in that. What they've added is the additional items paid by sellers section. It used to be set up as seller's contribution at closing. And so that was confusing for people because in the seller contribution at closing on page 1, if you put $0, seller felt like they should pay $0 of closing costs at all. What that section always meant was the seller's going to contribute X amount of dollars to the buyer's closing cost. But by setting up the paragraph, seller contribution at closing, it tied the two together and conflated the two ideas. So now you still have seller's contribution at closing, that is the explanatory paragraph for the amount you're filling in on page 1. And then they broke down another section, additional items paid by seller. Really, it doesn't change what the seller is responsible for paying. I just think it helps you guys in explaining it. It helps us in justifying our fees. It helps the seller to see a little bit more clearly what they would have to pay. Because I think when they saw that paragraph, that they wrote $0, they skipped the whole thing because they said, oh, it's 0. So now there's the additional items. So anything to prepare and record title curative documents, the seller not attending closing, and then that payoff of proceeds, handling and delivery fee. So all of those are seller costs, seller fees. So when you're representing a seller, you get the settlement statement, the prelim from the attorney, and the seller says, hey, what are these fees? I agree to pay $0. There's a very easy place for you to go to the contract and say, for the contract, you agree to pay these fees. Done, easy, makes your job easier, makes my job easier. So for the buyer's closing costs, it's interesting because they made a change at the beginning of the year where they broke these out and added number 4, all other title fees and post-closing fees. In the mid-year changes, they removed number 4. So they made a change just to take the change away. And so I think they were trying to make it a little bit clear and create a catch-all so that someone is responsible for paying for the fees. But what happened is most attorneys have a post-closing fee, and we would see the contract with this change. People thought, oh, my seller's not gonna have to pay that post-closing fee anymore. But, you know, all of the different firms just updated the name of the fee to call it the payoff and proceeds handling and delivery fee, because that's really what it was for. So they just updated the name. I think having this section was very confusing for people. It caused a lot of turmoil, did not create any sort of ease to use it, so they just pulled it right back out. So earnest money, you know, y'all have heard me talk about earnest money quite a bit. I think y'all's brokerage prefers for KW to be the holder of earnest money. I don't think it's worth losing a deal over, so there's nothing inherently wrong with the closing attorney or the other broker holding it. I just think your broker prefers to hold it, so they have control over the process. They know when it's not turned in and when to send out the notice. They can make sure the notice goes out on time, all of that good stuff. It's good to have that control. That being said, remember that if your broker is the holder, you still have to keep your broker updated on when things happen. And what I mean by that is, let's say your earnest money, you're representing the buyer, earnest money is due today. You know that the buyer has not turned it in. Tomorrow, you know that they still have not turned it in. Your broker's not gonna automatically know that. You need to make sure that your contract is uploaded, wherever it's supposed to be uploaded, and then saying, hey, and I don't know if it's Ruth or Kim or who you're supposed to notify, but you need to make sure you know who that is and notify that person. Earnest money was due yesterday, we still don't have it. And then they'll take care of sending the notice out, but it's still your responsibility to kind of keep control over that process and know what's going on. If you represent the seller, what you always want to ask about the earnest money is, has it been deposited? Not has it been turned in, has it been deposited? Because turned in, it could be sitting in your purse, right? But that doesn't do anybody any good. We don't know if the balance is sitting in your purse.
Right.
Has it been deposited? So just be careful about that. Y'all heard me say quite a few times, there's really no reason to have like 3-5 days to get earnest money turned in with wires, ACHs, and like places to drop checks. There's really no reason it should take that long. I think 1 to 2 days is plenty. I always recommend doing a wire because it's easier to get back. And then as soon as the person has the wire, hasn't been deposited. As soon as we have the wire, that money is in our account. There is no clawing back a wire. So with a check, I might have it, I might have deposited it, but in 6 days, I might run it bounced. And then we have to go through the process of writing that 10-day letter. So I would do a wire on that. The one change is in talking about the 10-day letter process. So who knows what a 10-day letter is for?
Notifying them that they don't have it, or they need to, know.
Give you time to investigate what happened to it before you issue the money back. No, kind of, so.
Closer, but still no. You got a guess? Okay, so, yeah, so what happens is if earnest money is not turned in, then you have to send out notice saying you don't have it, right? But what if earnest money is turned in and the contract terminates for some reason, right? You get the unilateral termination or one party terminates, but the earnest money section, both parties have to sign in order for the holder to release the earnest money to
Right.
one side. If both parties don't sign it, we only have one party signing it. And then we have to make a call as the holder. That's what the 10-day letter is for. Now, what do you think that 10-day time period defines? Is that how long we have to get the letter out? Anybody know what period?
to resolve the issue or just to,
It's for the parties to respond to the letter. So know that the 10-day letter is not gonna go out in 10 days. It's not even gonna be close to that. It's gonna be more like 30 days at least. It takes a long time. And the reason it takes a long time is because it's better for everyone if y'all just sign off on the split of the earnest money. So what we're gonna do as a holder is as soon as I get that termination, I see only one side signed it, I'm gonna say, hey, can you send me the fully executed earnest money section of the TNR? And then we're gonna go back and forth waiting on that, because probably your response is gonna be, sure, as soon as I get it, I'll send it over. You're gonna try to get it. Eventually, you're gonna realize I'm not gonna get it. You're gonna tell me, hey, they're not signing it, I need a 10-day letter. At that point, quite a few days have probably gone by, right? Because I know it's best if everyone signs off, and you know it's best if everyone signs off on it. So when I get that notice, I reach out to the other side. So I gather up all the information that I can to try to get everyone on the same page, try to convince everyone that coming to an agreement is gonna be better off for everyone involved in the transaction. Okay, if I really can't get everyone to agree, then I'll issue the 10-day letter, which that letter just says, hey, I've reviewed the contract, this is who I think should get the earnest money, and this is why. Parties have 10 days to respond to that letter to say, I disagree with you and here's why. If they convince me and I change my mind, I issue another 10-day letter saying, I've changed my mind, this is what I'm gonna do with it now. If they don't convince me, then I can proceed to disperse the earnest money as originally intended. What the change was, is it used to be that only the parties to the contract could issue like that, arguing letter, or the letter saying, hey, I think you missed this piece of information. Now, what they've said is other parties can also do that, and so y'all can see here, now it's any party, real estate licensee, or any other person having knowledge of or an interest in the disbursement of the earnest money. I think the reason that they added that is because there have been a lot of sales that are, I guess, elderly people, if you will, and their sons and daughters, we're helping them through the transaction. Like, hey, I need to, maybe mom is in a facility, she's got dementia, she can't handle it, and the son has power of attorney to help do the transaction. Well, technically, he's not a party to the contract, right? He's signing on behalf of someone else. Or even other instances where maybe mom is fine to sign everything, but she's really relying on her child to help her like walk through the process. Now that child can help write that rebuttal letter saying, hey, you missed this. And it's a lot more efficient and honestly helps everyone kind of in the long run for anyone related to the transaction to be able to write that letter. I don't know that y'all are gonna use that a whole lot, but I think it is helpful if you do get in a situation where
Absolutely.
that's needed.
Yeah.
I think it also might be helpful if maybe you're representing a client who doesn't speak English very well, and they're not gonna be able to craft a rebuttal letter that's gonna be very convincing just because they don't speak English. Then you as the like bilingual person can help craft that letter. I think that's gonna be a helpful thing there. Question for you guys, little quiz. Is there any scenario in which the holder cannot issue a 10-day letter and has to interpay the money, which means sending it to the court, so the court makes a determination? Which, by the way, is not a great resolution because they're gonna pull the cost out of that earnest money amount before they distribute it. So nobody wins if it gets interplayed or interpolated. But anybody know if there's a situation where it has to get interpolated if parties can't come to an agreement?
If it was an all cash deal? I say if it was an all cash deal,
But it's a two-pronged thing, all cash deal and what?
I don't know the or what.
So
And Joe is not involved.
it's an all cash deal where the closing attorney is the holder of the earnest money. So if it's an all cash deal and the broker is the holder, that's fine. All cash deal where the attorney is the holder. And the reason for that is in an all cash deal, we don't have a lender to represent. So what the contract says is we represent the buyer in the limited capacity of getting docs recorded, signed correctly, sending money to the right spot. But technically, since we represent the buyer, we are not in a position to be able to make a decision because either we're biased or we're not representing our client well. So we can't do the 10-day letter in a cash transaction where we hold our money. I think this is gonna be a really helpful change for you guys to use. It doesn't really change the way that we've operated necessarily, it's just added language into the contract that makes it more clear for everybody. So this is in the due diligence section of the contract, but buyer has a right to inspect the property through closing. So it doesn't matter whether you have a due diligence period at all, or if your due diligence period is already concluded and we're past that date, buyer has a right to inspect the property. I think a lot of people conflate due diligence and an inspection period. Those are not the same. Due diligence period is not the time frame that you can inspect the property. Due diligence is the time frame that you can terminate for any reason. So does it make sense for you to do all your inspections in the due diligence period? Absolutely. You should try to do everything you can in that due diligence period, because that's when your buyer has the leverage to be able to terminate the contract. But your buyer absolutely has the right to inspect the property after the due diligence period has ended, right? We all know that the buyer has a right to a final walkthrough, which is in some regard a type of inspection, right?
Right, yeah.
So that continues all the way through closing. What they've added is this highlighted bit. So the seller, has always had to keep utilities on, system and equipment to be on, and they added all parts of the house to be accessible, including basements, attics, and crawl spaces, so that buyer may complete all inspections. I think there was an issue with people like blocking their basement door and not letting people take a look at that, or the attic, or maybe even the garage. Like I had a closing where they couldn't get into the garage. It was locked and they had looked at it before, I guess, but for the final walkthrough, the garage was locked. Well, the buyer comes to close it and they're like, I'm not gonna finish the closing until I've been able to see the garage. And they had every right to do that because the seller was in breach by not having it open.
Right.
Turns out the seller wasn't doing anything sketchy. They had just forgotten that they locked it and weren't in the vicinity, didn't hear their phone. So after closing, we closed an escrow. She went back, she looked at the garage, she emailed me, everything's fine. We finished closing and moved on. So ended up being okay. But know if you represent a seller, that they need to have all of the places of the home open. And honestly, it's kind of a red flag for a buyer,
Sure.
right? If you have this room that's locked, it's like, well, why don't you want me in there?
Yeah.
Right? If it's a closet, you might think, okay, you put your valuables in there, but if I can't get in the whole basement, it's not a great sign, even if it's something that was innocent. So just make sure your clients know that all of this has to be accessible and available for the buyer to see. Again, this is one of those make sure life easier in explaining why, because you can just point to it in the contract. Rather than sort of kind of pulling at straws, grasping at straws to explain it. What happens when the due diligence period is over? How is the property sold? As is, yeah, say it's on the screen, you got it. So if you have a client that wants to put into the contract that the property is sold as is, does that make a lot of sense?
No, it's already in the contract. You don't wanna create language that makes it more confusing or takes
Yeah.
rights away or.
And so I think it's important for y'all to know where that is in the contract. The due diligence section is paragraph B8 of your contract. And so know where you can point to that. Because if you have a seller that says, I want it to say that it's sold as is, and you say, oh, the contract already says that, you're fine, you don't need that. They're probably not gonna believe you, right? That's just people who really wanna see something in writing, want to see it in writing, and that's just how they are. But if you say, it's already in your contract, let me show you where you see this sentence, then they're a lot more likely to say, okay, perfect, and move on with it, then you don't have to put it. If you have someone who is like,
Then you still
I
put
don't
it.
care, I want it in there, put it, but make sure they understand what that means. So does that mean that a buyer can't ask for anything in the due diligence period?
No,
No, buyer can ask for whatever they want.
sure.
So if you have due diligence, the buyer still has a leverage. So make sure your sellers understand that you can put that all day long. Doesn't really change what the buyer is gonna do, or what the buyer has the right to ask for. Even if you don't put as is, seller never has to sign an amendment to address concerns. Buyer could terminate, but seller doesn't have to sign it,
Right.
right? Also know that putting as is does not relieve them of the obligation to disclose hidden defects. If there's a hidden defect, Georgia law requires that if they know about it, they have to disclose it. There's no contracting around that. That's the law, not the contract. So just make sure that,
All right, where is that contract paragraph?
B8G, let me see if I can tell you the exact subparagraph of it.
D as in dog?
No, B8,
Yes, boy.
B is in boy.
All right, thank you.
And there's a bunch of subparagraphs to that, but it's in that due diligence section, and I can find that here in a little bit, and I can send that out if you'd like.
Not a problem. I just want to write it down.
The other thing that they've changed, which is this kind of a new year change that they went back and fixed in the mid-year changes. So in the new year, they added this whole paragraph. So basically what that's saying is if buyer or anyone buyer who's brought into the property damages the property, it's the buyer's obligation to restore the property to where it was or better, which makes sense, right? If you are a buyer and you want to inspect the seller's property and you bring in an inspector and they're walking along the attic and they fall through the attic, the buyer should pay for that, not the seller. It's the buyer who wanted the inspection, the buyer who brought the inspector in. That makes all sorts of sense. But what was happening was, what if there was some issue with the property that already existed? And by doing an inspection, this defect was discovered and created a problem. Is it really fair for the buyer to have to restore the property to being in good working order when there was already an issue? So that's why they added this last sentence that says, notwithstanding the above, this indemnification obligation shall not apply to damage resulting from defects in the property uncovered during the inspection of the property.
Right.
So you've got like a huge leak in the ceiling and the inspector's walking and they just barely touch it as part of the inspection and the whole leak falls through. It doesn't really make sense for the buyer to fix the ceiling when that leak has been there, right? That water has been sitting there, it's already an issue. So that was kind of maybe uproar is a little bit of an exaggeration, but a complaint that they received after adding this paragraph. So they've adjusted it to make it more fair, if you will.
Good idea.
Brokerage relationships, we're still in the purchase and sale. So in the new year, they clarified the no agency relationship, that is a customer, you know, the person is representing you, is that you as the agent represent the client, not the customer. But in the mid-year change, they wanted to clarify what designated agency is. So dual agency is, you know, I'm representing the buyer as a client and I'm representing the seller as a client. Your broker allows for that, but you have to have specific permission. And honestly, I would never do it ever for any reason, ever. I would never do dual agency because I don't know how you represent a buyer wanting to pay as little as possible and a seller wanting to make as much money as possible in a transaction. Those are by definition adverse. I don't think anyone can do a good job doing that. But designated agency is where Chat North, the broker, is representing the buyer and the seller, but two different licensees, two different agents representing the buyer and the seller. So that just puts that language into the contract, makes it a little bit more clear for the buyer and the seller. So I know you guys know what that means. There's a helpful definition to kind of point to there. Again, nothing is really gonna change your life a ton. I would say the biggest kind of theme for the changes in the mid-year, we're adding language on hazards. I think there have been quite a few lawsuits where people have gone into a home and to view the property and tripped, or something happened to them and they got hurt and they've been suing the agents, the listing agents, saying, hey, you should have known that, you know, this stair was too big and I could have fallen. And I think some people have actually died, like some elderly people have like fallen down a step, hit their head, not made it, that kind of thing. Which is super sad, right? But not really the listing agent's fault. And quite frankly, not really the listing agent's problem. It never should have been the listing agent's problem. They just added a little bit of language really to protect you guys. So brokers shall have no duty to inspect the property for defects, hazardous conditions, repairs, or any other matter to advise buyer or seller, blah, blah, blah. So that just absolves you of that responsibility to actually go look at the property to determine whether there's any defects or hazards.
So liability falls back on the property owner.
Right, right. Now, the seller, of course, has the obligation to disclose any sort of issues or hazards that they know about. I don't know that they have the obligation to go comb through the house and look for every possible defect or hazard. But if you know, like, hey, I've got a staircase where the last stair is 4 inches bigger than the others, you might want to disclose that because, you know, you get in a rhythm walking down the stairs. Sure. And then it's extra and you fall. That kind of thing. Your seller knows about it. They need to be disclosing that, but this just helps you guys out.
Who's handrail, I guess? Yeah.
Yeah, any sort of defect that your seller knows, but again, it's the seller. It's not you guys. That being said, if you know about it, you might as well disclose it,
Yeah.
right? But it's not on you to go figure out whether there's any defects or hazards with the property. So we're gonna see this theme in quite a few places in the various forms. There was, I guess, a big push to protect you guys, because we all know the forms are set up to be as even between buyer and seller as possible, but with the underlying and consistent theme of protecting you guys as the realtor. Very slight modification here. This is in the default section. So the default section says what a buyer can do if the seller breaches, what the seller can do if a buyer breaches, and then what the agents or brokers can do if either side breaches. That used to say to every broker in the transaction. Now it just says to broker. I don't really know why they made that change. The only thing I can think of is to be consistent with the title. It doesn't say rights to all brokers, it says rights of broker. It's singular, now they've just matched that. So I think that is really the only reason, again, nothing earth there. Another very important, since my sarcasm a little bit, change, it always cracks me up, they always have some sort of definition that they want to add to the contract that we all know what it means. But I do think that this one is helpful for your buyers and your sellers. So they've just defined what a client is and then what a customer is. And what I think is good about this is that customer is a party not represented as client, and broker may only perform ministerial acts.
I think it's more for the client, for the actual buyer,
Absolutely.
than for you. Yeah,
And or seller, depending on who it is.
sure. Yeah, yeah, it's good.
I think it's a good thing for them. It's just funny because we all know what those are,
Right.
but
But we can expect probably the layman to know.
precisely, and I think that was the other theme in the changes is, okay, how can we make real estate agents and realtors' lives easier in explaining the various things that happen? Let's make it super clear in the contract. Let's give them a really easy place to point to say, this is what this is. So, because you could say what it is before, but if they would say, how do you know that or why? You would say, I don't know, that's just how it is. Now you can say, because the contract says so.
Right.
Boom, done. For the other different purchase and sale agreements, so the lot, the land, new construction, all of those changes that we just went over for our regular purchase and sale are consistent through all of those forms as well. Temporary occupancy, what is my thought on when we should utilize temporary occupancy? Not the form, but the concept. When do we
Never.
want to do that?
Never.
Never, yeah, as much as you can avoid that, you should avoid it, because there's all sorts of heartache that comes up
Right.
with temporary occupancy. Okay, the biggest one being seller is responsible for fixing any damage that they create during the temporary occupancy period. If it was before, then not the seller's problem, because the buyer bought it like that. But the problem is your buyer can go do a walkthrough all day long, but if all the seller's stuff is in the house, you're not gonna be able to see everything that they could have possibly damaged. Then when you go back for the walkthrough, you see that there's scratches on the floor. It's like my classic example. Buyer's gonna say, you scratched the floor moving the fridge out. Seller's gonna say, I scratched the floor moving the fridge in, you bought it like that. How are you gonna know? You can't prove it. So stuff like that comes up all the time. Or them not leaving the property. That comes up all the time as well. So we have the holdover rent paragraph, which is saying if the seller stays past when they're allowed to, they owe the buyer a daily, essentially penalty of how much money. Now, how much should that be, you think?
Very, very high, very high. More so than any hotel or Airbnb or anything that they can get.
Yes, so you want to take into account what the mortgage is every month. So what's the cost of owning this property? So not only just the mortgage, but your taxes, your insurance. What is your carrying cost for this property? What are you paying as a buyer to live somewhere else? Do you have to pay any sort of penalty to extend your lease or what have you? Are you putting your stuff in storage? What's the cost of doing that? Do you have to have other people assisting, maybe like, do you have to board your dog? What, like all of those costs, take that into account and then make it hurt for the seller. You can't make it so high that a court could say that it's ridiculous, right? If you put $20,000 a day and you're talking about a $400,000 house, they're gonna throw that out. They're gonna say that's ridiculous. Your carrying costs cannot be anywhere near that.
Yeah.
If you live in a $10 million mansion, then maybe, who knows? So it's somewhat dependent on, of course, the cost of the property. No, you have to justify it to some degree if it were to come up in court, but big principle, make it hurt for the seller. Like $500 a day, $1,000 a day is gonna hurt for a seller, and it's gonna be enough for your buyer to sue over if they stay for a relatively long time.
Right.
Also know that the closing attorney can't enforce that, right? We can say, we can send an email saying, looks like you've exceeded the amount of time you're supposed to be there. Your contract says you would owe them this amount per day, but that's really all we can do. So that's the other big risk, is that if it's before closing, the buyer cannot close because the seller hasn't moved out. If it's temporary occupancy, the buyer already owns it. The only way to fix it is to evict them. So it's kind of a lengthy, time consuming, expensive, not fun process. And there's no one that can come in and force that and like quick fix it for them. But what they've done as far as the change is they've added, that the seller will be liable for such damages, including actual attorney's fees reasonably incurred as buyer can prove because of seller's wrongful failure to vacate. So if they are evicted, they would technically owe the buyer that cost, as long as it was reasonable for the buyer to have incurred that attorney cost, right? You don't want to have like the average hourly rate for an attorney be $600 and your buyer chooses one that's $1,500 an hour, you know. As long as it's reasonable, then they would be owed those fees back. Again, keep in mind, if the seller doesn't have the money or is not willing to give it, they're gonna sue them and they may or may not end up with it. It's not like a surefire thing that it'll be immediately in their pocket, but they at least have the right to get that back. The brokerage engagement agreements. So what they've done is they've reworded this hazardous conditions paragraph, made it more advantageous to you guys, again, following that theme of trying to prevent people from suing the realtors and the brokers over hazardous things that have caused injury. So kind of general idea, but just giving it a little bit more weight, a little bit heftier, a little bit more protection for y'all as the realtors. There were several changes in the buyer brokerage agreement, and we'll kind of go through those one by one. So as far as the limits on y'all's responsibility, they did add language, which I think is really helpful for you guys if you have multiple buyers going on at the same time. It says that y'all may show properties in which buyer is interested or in which buyer has made an offer or counter offer to other prospective buyers and assist such buyers in making offers and counter offers on such properties. So what was happening is, let's say you represent me and as a buyer, and maybe you're also representing me, let's say, as a buyer. Well, I want to go see 123 Cherry Street. I love it, I think it's perfect, and I want to make an offer. But Mindy also really likes 123 Cherry Street, and she wants to make an offer. Now you're kind of awkward because you represent both of us. So your two clients are competing against each other.
Right.
I think there probably were some lawsuits, definitely some complaints saying my agent's not representing me well if she's writing an offer on the same property I want for another client. This makes it very clear that you are able to do that. So now you can point and say, no, I'm still representing you, I'm still putting your best offer forward, has nothing to do with putting Mindy's best offer forward. Or both, you know, following what you guys want me to have in the contract. I'm advising you guys to the best that you each can do. I'm fine to put in offers for both. Just allows you to do that. And again, our good old favorite additional language on hazards. And they literally just added any hazards, because it used to just say any matter relating to the property, but they wanted to be super clear that you as the agent don't have the duty to inspect the property, to advise either side regarding the hazards in particular, or any other matter. They just wanted to make it clear that hazards were included in that. You have a question? No. Again, still on that hazard train going on. So they added these two sections here. Again, still response to that wave of lawsuits where people were getting injured in properties. Again, trying to protect you. So the buyer is acknowledging that there could be hazardous conditions on the property and they should use extreme caution in viewing the property, as should anyone they bring with them. If you want to bring your 94-year-old mom, you are absolutely welcome to, but do so at your own risk. And you and your mom need to look at the property and make sure that it's safe before proceeding. And then it also, this hold harmless language, they're holding harmless any agents.
Yeah, it's pretty cool.
Yeah, so yeah, it's a great change for you guys. Not going to really change how you do business very much. But if you do have an issue where someone gets hurt, you know, have lots of language in all the various forms protecting you against that.
It's funny because I've shown two houses recently, both over 650, in which there were some major hazardous areas in which somebody could just fall to your death. And I'm surprised there was no railing or anything. These are really expensive homes. But I merely caution buyers, careful to go over there. If they have kids especially, you know,
Mhm.
can just go running out.
Yeah, and I still think it's fine for you to say, hey, I noticed there's a ledge, be careful over there. It's not that like you shouldn't say anything, but
Sure,
you're not responsible for going to see if there is a ledge and then coming and advising them on it.
sure.
So feel free to advise them, but these paragraphs really help you guys out in potential lawsuits. Authorization to show unlisted property, when do we use this form?
Where's for sale by owner?
And what?
I'm taking a buyer to show it.
Exactly. So, and I make that distinction because if you have a for sale by owner that you want to get to sign a listing agreement with you, you get them to sign a listing agreement with you, the exclusive seller brokerage engagement agreement. This is, I'm not trying to get you as a listing, I just want to show my buyer your house that you don't want listed.
It's a long form.
It's
It's
what?
a long form. There's a lot of information to fill out.
Yeah,
It's
but
like 4 pages. Sucks.
yeah, but also.
I know.
It says that they'll pay you commission.
Right.
It's kind of important, right? Make it as many pages as you want, as long as you.
No,
can
definitely, because from the very beginning, it stipulates what the price is, because it's not advertised, right?
Mhm.
And then the commission that they're paying out.
Yeah, so just make sure that you're using this, otherwise you don't really have a right to show that property, because you're kind of marketing that property, even though it's to that one, buyer. You're still doing realtor activities, so you don't have any sort of authority to do that unless you get this form signed.
Is it, a stupid question, but is that something that, for example, if I have a buyer that wants to go see the property tomorrow, and he says, Fishbowl, I should go today and meet with the owner so we can get this hammered out,
Yeah, I wouldn't do it in front of your buyer.
right?
Yeah,
Exactly.
I would go separately, whether it's the day before, week before, hour before, whatever.
Right.
If your buyer wants to do that, you can say, yeah, no problem, there's a form that I have to get the seller to fill out, that's gonna authorize us to go look at the property, so let me get that set up, as soon as I have it, I'll let you know, we'll go check the property out. That's how I would handle it, because you want it done before.
Yep.
It'd be very awkward to do in front of your client. Nothing wild as far as changes go. What they did do was move the protected period paragraph just up an additional page so that there's not like a hanging header, if you will. They just put it all on one page so it looks prettier, but didn't really change what that is. What is the protected period? Who knows what that is?
It's when your client terminates a contract before a sale has occurred. And it turns out that 2 weeks later, a buyer that you already shown the property, they say, I was representing the seller. And a buyer that already came to see it during my contract, now wants to make an offer. So because he came while I was the listing agent, then I should get the commission, right? Something like
Yeah,
that.
more or less. So it's the period after either the expiration or the termination of the agreement that your commission is still protected, so long as you're the procuring cause of that contract coming together. Whether you're on the buy side, the list side, or this authorization to show unlisted property, that protected period is just after the conclusion, for whatever reason, there's a time period that you're protected to get your commission. The exception to that is if it naturally expires, or if there's a mutual termination, then they go sign a new listing agreement that cuts off your protected period. Which I think they have it like that, because if it's come to its natural, expiration, or y'all have mutually terminated, there's no, like, anyone gets screwed, if you will, for lack of a better term. It's come to a somewhat reasonable conclusion and they can move on and find a new agent. And then that agent deserves a commission because it didn't happen while you had that listing. If it's a unilateral termination, like if the actual seller, buyer, owner of the property unilaterally terminates, then that protected period is after the expiration of the contract. But just know that your money is protected, it's really the point of that. The only change again was moving the paragraph up, so nothing wild there. Again, added some language shockingly on others to protect you on that front.
Yes.
Question, Ashley, I want to make sure I understood what you said. If the contract naturally terminates, let's say 3 months later, naturally terminates, and you did show a client a week before it naturally terminated. That person comes in and wants to buy it 2 weeks later. Don't you still get that commission?
So long as they have not signed the new listing agreement with the new agent.
Wow, so you're not
Right.
protected.
But even if you showed them and they signed the new listing agreement and then that buyer that you showed first goes with that new agent, you lose it?
Yeah. Yeah, you're protected, period. Now, could you make an argument that you were the procuring cause and bump the other agent? You could try that, but the way the contract is set up is that that protected period is cut off as soon as the new listing agreement is signed. So if they actually decided to go under contract before then, and maybe they should sign the document, you might could make the argument that it still happened in your protected period. I think it's gonna be a tougher argument to make. You could do that, but for the most part, it's cut off once the new listing agreement is signed.
All right.
So the one thing to protect ourselves is to have obviously a list of what properties I've shown you or who came into the listing that I have and all that.
Yeah, so there's no like one clear, this is procuring cause. It's sort of a totality of the circumstances as we like read about in a lot of court cases. But yeah, having lists of properties that you've shown buyers, having lists of buyers that have either come view the property or made an offer on the property and the dates, that's certainly going to be helpful in showing the procuring cause.
Totality of what again?
Totality of the circumstances.
Okay.
A legal kind of word.
Right.
Real quick, this is not a mid-year change, but it was the most important change in the new year, in my opinion, so I just wanted to touch on it again. The amendatory clause in the FHA financing exhibit used to be a total get out of jail free card. If the appraisal came in $1 low, then no matter when in the process, the buyer could terminate.
But that was in January, right?
Yeah, I said it's a new year change. I just wanted to go over it again.
Gotcha.
No mid-year change as far as the amendatory clause goes. Again, just kind of a reminder, but I think it's super important. Want to make sure we're all utilizing it correctly. So it used to be total, you can terminate, you don't have to do anything with the seller, you don't have to give them a chance to reduce the sales price. The buyer, as soon as the appraisal comes in, either that minute they could terminate or the morning of closing, they could terminate using that amendatory clause. It is not like that anymore. Okay, so it still runs all the way up to closing, but now the buyer does have to give the seller the opportunity to reduce the sales price. Because the way it reads is that if seller is willing to reduce the sales price, then buyer shall close. Which doesn't mean buyer can choose to close, it means they have to close.
Right.
So that to me is a huge change in how we operate, because what was happening is people were saying, okay, my appraisal came in low and I don't care that it's $100 low, but now all of a sudden the seller is not replacing the 3 windows I want replaced. So I'm going to terminate really because the window issue, but on my termination, I'm going to cite the amendatory clause.
Right.
Now you just can't do that anymore. So this is a lot more even, if you will, for
Right.
buyers and sellers.
Sure.
It should make getting your FHA loans accepted just a little bit easier, as long as you're working with someone who's knowledgeable and understands. I think this goes a long way in helping them get accepted. But again, this is new year change, but it's the most important one, so I just wanted to give a reminder of that.
Because it was already
Question.
like getting conventional.
A little bit different for, yeah, it works like the VA one first time, yeah. No
Question, Ashley. Recently, I haven't done many FHA contingency programs, but I did recently. But here was my question. I put in the quote, or we made our offer at 530,000, but I had an escalation clause that would take it up to as much as 550,000. So when I came to put in how much the appraisal had to be, I just put it in at the asking price of 530, but it could have been, by the time we signed the contract, 550. What's the situation for the appraisal value then?
So the appraisal value is gonna be what you wrote in. Now, lenders are gonna require that it matches the sales price. So whenever you do an escalation clause, you always want to have something in writing, whether it's notice, I prefer an amendment, clarifying what that end sales price is. So if you say it's 500,000 with an escalation clause all the way up to 550, you escalate it up to 530, then I would do an amendment to the contract clarifying that the sales price is 530, and then paragraph, whatever paragraph it is, in the FHA exhibit that puts in that value that the appraisal needs to reach, you want to amend that as well. So just amend
I see.
both.
All right, so do it with amendment so you know exactly what the appraisal has to be. All right, thank you. And in that same light, question on FHA. So typically with a conventional, you have a financing period and you have an appraisal period. But there is no appraisal period in FHA. Is the financing contingency to make sure that you are, ready to go? I think I just made it 7 business days. Is that possible with FHA, or do you need to usually make it longer in this market?
Lender. 100% of your loans, I would ask your lender how many days they need.
7 is a little tough.
Because, yeah, typically FHA and VA, they tend to take a little bit longer.
Yeah.
But I would always ask your lender and they can tell you how many days they need. I would never guess at it, ever. Just
Well, I
because,
had to in this case because it was over the holiday and we couldn't get a hold of the lender, so I just guessed. All right, makes good sense. Thank you.
You still amended, Joe.
well, you can amend it on the other side.
Right, of course.
So moving on real quick to the VA exhibit, in the new year, they changed it to where the buyer or the seller would pay for that initial termite letter. Any sort of repairs that have to be done, any sort of additional inspections post repair have to get paid by the seller.
Right.
That's still true, but they qualified it, what they clarified is that seller paying for these repairs and for that additional letter is in addition to any other contribution.
Notified it.
Yeah.
So.
Yeah, and so the issue was sellers were saying, okay, but I put $0 for contribution. So if I had any money there, I would pay for it, but I've already said zeros. I'm not paying this, which is not really the correct interpretation of the contract because it's not a value closing costs, but this makes it really. Also, if you're saying I'll pay you $1,000, well, if all the termite stuff is 500, sellers will say, yeah, pay the 500, so we're gonna give you 500. So now there's no question, all this termite economy is over and above any sort of seller. Okay, this one, kind of a silly change, they changed total overhaul of this form in the new year. All they've done in the new year is correct the name, the bottom of the report, it says the name of the form number. They changed the title up top, they changed the footer, so they fixed. And then no big changes to the CAD in the new year or in the baby, which is really great. The only change.
I don't know if it's just me, but all of a sudden I'm having a little bit of trouble understanding you. I don't know what's happened. It's been clear till now.
Yes, the microphone sounds bad.
I don't know what to do about that.
Maybe speak towards the microphone a little bit.
Is it better if I stand over here?
That's good. You're good now.
Oh, yeah, she got to be facing the microphone. Yeah, thank you.
So the only mid-year change on the CAD was that they moved a hanging header up to the next page. So nothing crazy. Get my exercise in today. Okay, F510 and F511. Only change, it used to be, so what those forms are for is if the closing attorney is the holder of the earnest money. You're not gonna use this at all if a broker is a holder of the earnest money, okay? It used to be that we had 3 days to agree to be the holder. So in both forms, wherever it references that 3-day time frame, they've updated it to be a 5-day time frame, given a little bit more time. I think there were a lot of confusing situations where the attorney wasn't signing it in that 3-day time frame. And so what happens is that it automatically reverts to the alternate holder. Nobody was really following that. I don't know that this is gonna fix that, because in a lot of cases, I think it's getting signed super late. But technically, automatically, the holder is your alternate, which needs to be a broker, if the attorney doesn't agree. So just giving us a couple more days, giving y'all a couple more days to get that form sent in. As far as F510 and F511 goes, which one or both needs to be an exhibit to your contract? 510, that's correct. What is 511 for?
The actual third party.
Yeah, it's for us as the closing attorney to agree to hold the earnest money. I think this is a helpful change and it's gonna create a lot less confusion. You know, the unilateral termination is 2 documents squished onto 1 page. So the top half is the actual termination, 1 party signs it. The bottom half is the earnest money distribution or agreement on what we're doing with the earnest money.
Right.
Both parties need to sign that, or the holder has to issue the 10-day letter or interplead the funds.
Right.
So it used to be that it had buyer and seller for the earnest money, buyer and seller for the unilateral. People were getting confused saying, okay, both sides need to sign the actual termination portion. That's never been true. Unilateral literally means one direction.
Right.
So let me show you what it looks like. Now you see instead of buyer and seller, it says party giving notice. So now it's just the one side that has to sign, and it's very clear you don't need both sides to sign this portion.
Right.
Earnest money portion has remained the same.
Yeah, okay, that makes sense.
Very, very small change. There was an issue with the way the numbering was on this net to seller form. Now they just fixed the number, so there's no question on what's supposed to go in that one. Probably not gonna change how you use it at all. You probably didn't even notice that there was a wrong number and you just did it how you were supposed to do it. But now when you have the clients who pay a lot of attention, it'll have the right number there. And those are all the changes. So like I said, nothing super crazy. Do y'all have any questions for me?
You did a great job.
Well, thanks. I appreciate it. Stop the share.
My only comment is, just get it right the first time, you don't have to be making changes all the time.
Well, some changes, you don't really know you need them until you do.
Right, I know,
So,
it's kind of cool that we can do this, actually, that we can make changes.
no, I think it's awesome. And then when different things in the market come up, then you know exactly how to handle it. You know what I mean? Like with the backup offer form in the new year, nobody had ever needed more than 1 backup. That was something that people thought, didn't even think of, right? But then when you have 42 offers, you want a couple backups.
Yes.
So they've updated the forms to make that a thing that's user friendly. So I think having them updated constantly is really excellent.
I could be wrong, but I think it's the only industry that actually does change contracts twice a year or has that, you know, potential thing. Many other, you know what I mean? Yeah, we haven't worked in all the others, but I'm saying that just because you don't see that often.
Yeah, yeah,
It's cool though.
I don't know, but I think it's really good.
Yep,
I think it's a really, really good thing that we have going on. But if y'all need me, have questions,
thank you again, Ashley. You're
thank
great.
you guys for coming.
Yeah.
Appreciate all of you guys.
No one explains it clearly.
It was great. I learned some stuff.
It's quite
A
a
few things here and there.
I like it, I like it.
Yeah.
And I'm happy to send out the PowerPoint if anyone wants. I try to write it down every time who is here.
Yeah,
But just shoot me an email if you would like it in case I missed.
that'd be good.
Okay, I don't think I did anything.
And
Hey,
what?
Mark.
We're going, yeah.
Okay.
Yeah, that's how you face.
I'm gonna hold people over there.
Well, it is nice to see you.
I think you too. You did a great job.
Thank you so much.
Very understandable. Very
Mhm.
39,
Yeah, yeah.
They have been trying to put everything in there, they fired those that wanted.
Mhm.
We have been looking for 30 years, but the sellers closing right under us for new home.
Okay.
So they are now trying to see if we can close a burger, so she can. For some reason, she doesn't wanna leave the truck ready, ready to move, so.
Yeah.
I
I think, did you email us about that this morning?
Yeah.
Okay, Lindsay was looking at that, and she asked me about it. It's just, I have something already at those time slots, so we're seeing if the Maxine can come over to do those. So as soon as we've got it worked out, you know,
What
we'll
you think of is not just trying to, it's just not trying to avoid that. Precious days.
right, yeah, no, totally understand. She's working on it for us, so as soon as we've got it worked out, we'll get from her. You're so welcome. Good to see you.